My name is Cofer. I'm a federal criminal defense attorney. I practice in Texas and federal courts throughout the country. I want to talk to you a little bit about detention hearings. So, you may have some experience with bond and being released on surety bonds, personal bonds in state court. But if you have a loved one that is facing a federal charge, then you're going to go through the process of a detention hearing. It's very unlike the state court system in many ways. So first of all, the timing of the detention hearing. When someone is arrested, brought in on a federal charge, they're going to have their first court appearance. We call that the initial appearance, where the magistrate judge is going to tell the person about their rights, ensure that they have an attorney, and go through some other administrative steps. Then a detention hearing will be scheduled sometime shortly after. Generally speaking, a detention hearing is going to be between 3 and 5 days after that initial appearance. You see, the government, the prosecuting attorneys, they have a statutory ability to ask for an additional 3 days, and they almost always do that. Now, your defense attorney or your loved one's defense attorney should be trying to get the government to agree to release on pretrial conditions. But if they can't do that, then you'll go forward with a detention hearing. Now, at that hearing, the magistrate judge is going to decide whether the person that is charged can be released on conditions or combination of conditions to ensure that they will appear for court and that there's not going to be a risk to the safety of a person or the community. Now, there are certain offenses and circumstances that create what's called a rebuttable presumption. And that means that the rules are the judge should keep the person in jail while the case is pending, unless the defense can put on evidence to show the judge why that's not the case. When the judge is hearing evidence at this detention hearing, the judge will consider the history and characteristics of the person that's charged, consider the nature of the charged offense, how bad the charge is, and also the weight of the evidence against a person. As a part of the judge's job in arriving at the correct decision, the judge, the magistrate, will consult a pretrial services report. This is where you may first be involved. So, a pretrial services officer who is an employee of the United States Probation Office has to compile a report that has criminal history, background information about the person charged. And most of the time, they're going to call someone from the defendant's family or a close friend to verify a lot of that information. Also, get some information about where the person might be released. The judge or the magistrate is going to consult that report in addition to the evidence that we have in open court at the detention hearing. So, if the defense lawyer for you or your loved one is working for you and doing what they should do, then you'll be contacted in advance of the detention hearing to work through what evidence can be presented. Usually we're going to be looking for somebody that doesn't have a lengthy criminal history, that has some stability, and that is willing to allow the charged person to come and live at their home, or at least vouch for them and say that they'll be a third-party custodian, a person that's going to be responsible for the charged person, coming to court and following all of the rules of pretrial release. So our office generally will call and go through the questions that you might be asked if you are a witness at that detention hearing. It's important that we have evidence of the hearing because remember the rebuttable presumption. The reality is most of the charges that the federal government brings have a rebuttable presumption of detention. So we're going to have to put on some evidence to convince the judge that your loved one should be released. Now, the truth is, in most federal cases, pretrial detention is the outcome of the detention hearing. In some cases where our clients have a hold from another agency or detainer, we might even advise that our client waive the detention hearing and reserve the right to have the hearing later if the detainer or warrant is lifted. What's important to know as a loved one, someone trying to help out, you need to make yourself available to the pretrial officer doing the interview. Be smart about how you answer those questions, and also communicate with the defense lawyer's office to prepare for that hearing. Sometimes we may need to get letters, pictures, or other information that could be important evidence at those hearings. So the sooner you get in touch with the defense lawyer, the sooner we can prepare for the hearing, the better chance we have of getting your loved one out at that detention hearing.